Hi, this is Robert Coleman, and this is John Weed, and we have a video that we're going to do today. This is something new that we're going to try, but we're always working really hard to try to help people. And we have an organization called State of Grace. It's located in Huron, South Dakota, and I am the president of the organization. This is the vice president of the organization. And today I've asked some members that are on the group if they have any questions that they'd like to talk to try to get some legal advice. Now, I'm not an attorney, but John is. John, you want to tell a little bit about yourself?
Well, I spent the first 10 years of my life as an assistant attorney general in charge of 5 attorneys with the Highway Legal Department. Trying lawsuits, that was my forte. And since then, I came to Huron because an attorney who was with a firm of 5 passed away with a brain aneurysm, and he was their chief trial attorney. They needed a trial attorney, so I was selected, and I've tried both, for the state, and I have one book that's in process. It will be published within, the next 30 days or so?
Yes, it should be out pretty soon.
Anyway, that was what I really liked to do, and that's what I did. And now I'm retired, and I read Robert's book,
and here's the book, in case anybody wants to know. It is a large book. It's called At the Mercy of the State, and it is 546 pages long. That is in the book. John, do you want to explain a little bit?
I just wanted to comment on the reason that I'm kind of interested in helping your organization, Robert, is that I read the first pages, and I saw the transcript of when they took your children away, and it dawned on me that there's, as everybody probably knows, there's good police officers and there's bad police officers.
That's correct.
And there's good social workers that work with children and do a wonderful job, but there are some bad apples in the batch, and the prosecutor in Robert's case was a bad apple. They treated his children as though they were criminals, and they came to the motel where they were staying and took the children away at 3 o'clock in the morning with a cadre of like 12 officers, and they treated the children as though they were axe murderers, and it scared the hell out of the children. And then they kept them for a period of time without whatever. But anyway, to get the authority to take the children, they had a hearing on a Saturday morning, and the only evidence that was produced was a summary by this one social services worker and the prosecuting attorney, and they convinced this judge, that this family was just terrible and whatever, and they had to have this warrant to arrest them and get the children away from them, and do it in the dark of night and scare the hell out of everybody. They had no evidence. They, of course, should have had a hearing that the Colemans could either appear themselves or appear with an attorney and defend whatever the charges were. But the charges were all hearsay by this social services worker, and then undertaken by the prosecuting lady, that made it sound that they made it sound to the judge like this was a horrible, horrible family, and that, oh my God, we have to get those children away from them immediately by whatever way we have to, and we have to get our 12 officers to go to the motel where they're vacationing and take them away, and cause a big to-do. I mean, the hotel people and the people who were staying at the hotel probably thought that this was an axe murderer that the family were just horrible, horrible, horrible people. Well, they had no evidence that there was anything horrible going on. It was all hearsay, and they didn't have the opportunity to defend themselves. And that is happening, as I understand it, time and time again. And as I say, there's a lot of social services workers and prosecutors that are wonderful, wonderful people. But there's some that are really bad apples, and they do such terrible damage to the little ones. Anyway, that's kind of why I'm involved in this whole thing. Go ahead, Robert.
Well, we've had some questions. There was one from Missy Lemon who wanted to know that her son is going to be turning 18 soon. And he received a lot of emotional and mental anguish and also a back injury. Now, she wanted to know if there is a statute of limitations on a lawsuit with the state.
Well, the answer to that is any person who's a minor under 18, if anything is done to them in the way of a damage action or wrongful death or whatever, it's all postponed until the child reaches age 18, and then from that point on there may be in some states statutes of limitation that apply, but up until they reach age 18 there is no statute of limitation that applies whatsoever. Go ahead, Robert.
Okay, so hopefully that explains it. Another question is do the CPS workers need a warrant to come in and take your children?
They absolutely do, and like in your case, the problem kind of comes up when prosecutors get overly zealous in their jobs and they think, oh, we've just got to go, we got to go, we got to go, we got to do this. Well, basically, anytime you take children from the home, there should be an opportunity and a notice given to the family that this is going to come to a hearing, and a judge is going to make a decision on whether or not the children can be taken away. And the family has the opportunity to personally defend themselves or to have an attorney assist them in that. And without that, then it's just like Russia. It's like, oh, well, we'll have a secret hearing and we'll have whatever you want to call it, and we'll make the decision, and some judges, most judges are use common sense and are realistic. But there's some judges that are so wimpy that they'll just, maybe a prosecutor has been in their office for 10, 12, 15 years, and a new judge is appointed. Maybe he hasn't even tried a case, who knows? And so there's some judges that are so wimpy that they won't, require a protocol to be established. They won't require the prosecutor to say, let's have some evidence. Let's have a notice to the family. Let them have an opportunity to have an attorney. Let's have a hearing, at which time evidence, not hearsay, not over-the-back fence gossip has taken place. Have a hearing where absolute evidence is required that is really serious and sufficient to give grounds to have the children taken away from the people. It's axiomatic that it has to be done.
But John, I don't mean to interrupt you here, but as a person that got sucked into the system myself, they really seem to take everything as a civil matter. How is it legal that they can civilly sue you for your children?
Well, it's again the protocol and whatnot, and if I were to give my advice, and if anybody would pay attention to it, to take children away from a family should require some criminal activity against the children that has sufficient evidence to show that they did something really seriously wrong, and take them away. Because taking children from a home is a horrible thing for the children. Well, not only the children, of course, for the parents as well. But they probably would be better off if they'd make taking children from a home a criminal action.
Well, you know, as for those who are just stepping in here on the program, we're talking about in reference to the way these judges and attorneys handle the circumstances on removing children from a home. Now, I think that a lot of this is money driven. It's obvious that there's a lot of money driven behind this, because I have saw that there is more money funding for the state to remove the children than there would be for them to return the children. Now, we're from Huron, South Dakota. I have sat through a case out here myself. I've talked to several parents that have lost their children, but they've gotten them back within a few days. I've even seen the judge reprimand the prosecutor for some of the things that they've done in the case. Most likely when it goes to trial, or if it goes before a pretrial, the children get returned immediately. But I've noticed, like in my case in Michigan, they just go ahead and take these children away, no evidence, nothing substantial, and they just continue their proceedings for to take jurisdiction. So a lot of cases are at stages, wouldn't they be, John?
Well, like in your case, which I don't know how much of that type of thing is carried on in South Dakota, but in your case, first of all, they took the children with no evidence, okay? And you need evidence. You need facts that are substantial facts to take children away. It's just a horrible, horrible thing to take children from a home. It affects everybody. And they should, if it were all moved over to the criminal side of the courts, and evidence was required to show a criminal violation of some sort with respect to these children, it probably would be better. And you're saying in Michigan, this I have no knowledge of, but apparently when they take children from the home in Michigan, it produces income. For the social workers, it produces income for the prosecuting attorneys. And this should not be part of the system. It should not be a money-making operation. It should be totally divorced from money-making situation. And maybe to have it turned over to the criminal side of the calendar, where they have to have substantial proof that there's been a real criminal violation with respect to these children. It might be better, but you got to deal with things the way they are.
Well, we'll be back to you soon. This is part 1 of At the Mercy of the State. We're talking in reference to children being removed from the system, and we'll be back. Thanks for joining us.